Well, thank you very much. It is afternoon here, so I was about to say good afternoon, but I seem to think it's morning everywhere else, so I'll say good morning. Well, first of all, I'd like to thank Alexandra and Simone Glaney for inviting me to this symposium and to invite me to give a talk to you. I should say at once, I'm not a specialist in animal law, so that I'm coming to the topic from the position of a comparatist, looking at comparative law, rather than a specialist in animal law looking at comparative law. I did once give a paper. I think I'm right in saying it's the first paper that I attempted to give in French many years ago on animal rights law. And so I've had the topic at the back of my mind for many years. But other than that, as I say, I'm not a particular specialist on this domain. Now, turning to the topic, which I've called How Should a Comparative Lawyer Engage with Animal Law Studies? And I want to approach this topic from three questions, three broad questions. And these are the what, the why, and the how questions. The what, the why, and the how questions. But before doing that, I thought I would just say something briefly about comparative law as a subdiscipline of law, if you like, or as an area of law in itself. It's often said that it has a history starting in Paris in 1900 with a famous congress. I think this is rather misleading. That the idea of comparative, or a kind of comparative studies, goes back many, many centuries. For example, the attempt to look at English law through the eyes of Justinian's institutes, which pretty well once a century from about the 15th century, 16th century onwards, was relatively was an exercise that from time to time took place. And I would regard that as a kind, maybe top level comparative law, but it is a structural approach, if you like, to comparative law. Now, comparative law as a subject during the 20th century was really quite difficult to define in the sense that it was a sort of broad topic or expression, if you like, or an area of legal studies in universities that covered a multitude of sins. Sometimes it would just be an introduction to another legal system. An introduction to French law was quite common or an introduction to German law. Then, particularly after World War II, during the 1950s, the emphasis was on attempts to classify legal systems, a kind of taxonomy of legal systems, under headings such as families, legal families, which one associated with the late René David, or another top word was traditions, different legal traditions. One could associate it, for example, with Seibert and Kurt's famous book that was first translated into English by Tony Weir, by the late Tony Weir, who incidentally was one of my tutors at university, translated in the 1977 edition. But really, by about the 1990s, one realized that comparative law was really rather a kind of facile and sterile subject. And we saw from the 1990s a gradual development of a whole new approach to comparative, a whole literature to comparative law. Some of the early pioneers of this new approach to comparative law were professors such as Annelise Riles, and in particular Pierre Legrand, others such as David Kennedy, and in France, of course, Professor Horatio Muir-Watt. And this new, if you like, when I say a new, this how shall I say, this new approach to comparative law started to look at, tried to start taking a much more in-depth view of what the subject was to mean, what is meant by comparative law. Now, some people attacked this, or if you like, criticize comparative law as not meaning very much. It's you know, whereas students would be studying contract or tort, or property law, public law. These were boxes, if you like, or categories that contained, if you like, a whole mass of legal concepts, rules, whatever whatever your kind of ontological view of law is. But comparative law, there's no such thing, no such kind of positive law area, so to speak. And so the name came in for some criticism. I don't think that the name is that bad, actually. I quite like the name comparative law for this reason. I think comparison and law contain within them two fundamental questions. And these fundamental questions are, I think, should be the starting point of comparative law, or maybe preferably comparative legal studies. And these are, what is meant by comparison and what is meant by law. Both of these have attracted a considerable, looking back now from 2026, a considerable amount of literature. And they are questions that are by no means easy to answer, to tackle. By that I mean there are tensions within each of these questions that have given rise to a mass of debates, so that we see arguments about what is meant by law. We see arguments about what do we mean by comparison? What is it to compare? How do we engage with the other? What is the other? So that from these discussions started to emerge a number of what we might call quite serious problems. One of the most difficult problems, and I think controversial, admittedly, but still a very difficult problem, is what one might call legal colonialism or legal imperialism. This is where a lawyer, a jurist from one tradition, the common law, American law tradition, German law, French law tradition, looks at the other legal system, shall we say, that they are eyeing. My own example, looking at being a common lawyer, a largely trained common lawyer, although I should point out I was also trained as a Roman lawyer, looking at French law, and then attempting to somehow make French law conform to my vision of law. Or often the other way around, a French lawyer looking at English law, who starts to look at it, immediately approaches it from, the summa divisio of droit public and droit privé, and then drilling down a bit to distinctions such as between property as opposed to obligations. Now, this, of course, gives rise to huge problems, partly, of course, because English law traditionally does not distinguish between public and private law. There is just the common law that applies to all institutions, whether they be deemed public, private, quasi-public, or whatever. So that if you like, much of our public law, much of our constitutional law, actually, is to be found in private law. The famous historian Maitland ended his history of English constitutional law by famously saying that actually most of English constitutional law is to be found in the history of land law, the history of property law in the UK. And one could say the same thing about administrative law. For quite a lot of la responsabilité administrative is to be found in our law of tort, and to some extent to our law of contract as well, of course, as our law of property. So you can see the problem of a German lawyer or a French lawyer, Italian lawyer coming to English law with these kind of categories in mind. And the same applies to English lawyers attempting to teach, shall we say, their contract law to French law students or to German students. I mean, I myself have done a lot of teaching in France. I would say nearly half of my career is spent teaching in France. And the real problems of attempting to explain, if you like, English law often through concepts, particularly contract law, often through concepts of which are largely unknown or are strange to a civil lawyer. So we have arrived today with comparative law with now a very, very sophisticated, I think quite a sophisticated literature. In 1994, when my colleague at Lancaster University, who is now Professor Pierre Legrand at the Sorbonne, but he was for several years at the University of Lancaster, and my colleague, we had to formulate what we'd call an advanced comparative law course for students, Erasmus students, coming back from their year in a French faculty, German faculty, Italian faculty, or whatever. And so they'd be in their fourth year, and we wanted to produce an advanced comparative law so that they could use their knowledge that they'd picked up in continental Europe. And hopefully we would have a very sophisticated course. But when we came to try and plan the course, there was hardly any literature or worthwhile literature. There was Seibert and Kurtz. There was an famous article by Gunther Frankenberg, and basically that was it. There was a couple of articles by the late Otto Kahn-Freund, who had been professor of comparative law at Oxford, Harry Lawson, and one or two other people. But really, not a literature you could base a whole year's course. Today, that is entirely different. One could base, 3 courses on the current literature, an enormous amount of literature compared to 1992, 1993, 1994, an enormous amount of literature on comparative law theory, on comparative law method, on comparative aspects of comparison. And there's even now, which did not exist other than Seibert and Kurtz and René David's Grand Système, which had been translated into English. Now there are several textbooks. In fact, it's a bit like the story of London buses, that you wait for ages and then 3 come along at once. And then that was very typical of comparative law textbooks. There wasn't really any. And then suddenly there's 3 that come along almost at once. So there has been a drastic change, if you like, in the literature, the theory literature, the methodological literature, and so on and so forth. Well, that's just an introduction to, if you like, to give you an overview of the kind of subject comparative law that Alexandra, Simone, myself, Pierre Legrand, this is the kind of literature that we are now interacting with. So the comparative lawyer who turns to animal law. How should a comparative lawyer like myself engage with animal law? Very conscious that there is now a huge amount of literature and learning on animal law. I think one of the first, before I get onto my 3 questions approach, I think one of the most interesting things about animal law is that it's an empirical category rather than what I would call a conceptual category. The conceptual categories have these roots going back to the Roman law materials: contract, delict, property, jus publicum. These are, these are the kind of topics that you will find in nearly all civil codes, Code Civil, for example. Animal law, along with subjects like sports law, banking law, are different. They take an empirical object and then look at all the legal information that attaches or concerns that empirical topic. So that what is interesting about animal law is it'll cut across all of the conceptual categories. It will involve rules, whatever, material from public law. It will involve material, of course, from property law. Animals are treated as property. Certain animals, let us say, are treated, of course, as property. They are things. So very much objects in the law of property. And of course, if they're a law of property, movable property, if they were classified like rabbits in France as real property, then they would also involve often the law of contract, the buying and selling of animals. Actually, of course, you as animal lawyers, you will know that one of the most serious problems involving animals is the illegal trading of animals throughout the world. And of course, that, immediately the trading brings into play contracts, possibly the law of delict, tort, and so on and so forth. Now, let us start with the first question, the what question. The comparative lawyer is going to ask you this: what is it? What is your object? What are you hoping to compare? Are you planning to compare texts in country A concerning animals, directly or indirectly, with texts in other legal systems in other legal cultures? Or are you, these are not exclusive categories, are you actually going to be comparing things? Asking the question, fundamental question, what is an animal? What does the term animal include? Does it include, for example, a virus? Is that an animal? And what kind of animals do animal lawyers have in mind if they are, for example, thinking of animal protection law? Does that include all animals? Does it include insects? Does it include snakes? Does it include New York rats? Whatever. I mean, this seems to me to be a difficult question, and I'm sure many of you animal specialists are going to raise this in discussion. I hope you do. Mosquitoes, for example, these animals that require protection. And I mean, a law can change. I mean, an octopus, for example, was not included in animal originally and in our major animal protection statute until a subsequent change with as a result of, if you like, scientific research or a better understanding of this particular animal. The the other interesting part about animals is how do we classify? The comparator is going to ask is how do we classify them? Oh, well, what kind of taxonomy are we going to use? And here the comparative lawyer is going to think of often a decalage between how a zoologist might categorize animals in the UK and how a lawyer might categorize animals in the UK. I mean, let me give you an example. We have an animal, a statute called the Animals Act 1971. Now, this act would be normally taught to students in the topic of the law of tort, or to use the civil law term, the law of delict. And this classifies animals into various different categories. One starting point is the category of dangerous and animals belonging to a dangerous species and animals belonging to a non-dangerous species. Now, we have had cases on this. Does an elephant? We have a case where an elephant sat on a little person, and the question arose, is this an animal that belongs to a dangerous species or non-dangerous species? We have another category, animals belonging to a category called livestock, and animals that do not belong to this category. And different rules attached to this. So you've got a strict liability rule attaching to animals belonging to a dangerous species. If I take my tiger into the park next door to our house here and it attacks someone, I will be liable under Section 2.1 of this Act. If I take my huge, dangerous dog that is a menace to everybody, that will not fall under animals belonging to a dangerous species, because dogs do not fall into that species. That category under the Animals Act 1971. Nevertheless, we have another different statute called the Dangerous Dogs Act. So your animals law is going to look at this. Well, you've got English dogs, and one law says they're dangerous, another law says they're not dangerous. So you can see immediately that there is something of a decalage here between how a zoologist or how an ordinary person might classify animals and personal. Now, this kind of problem isn't confined to the UK. So one of the things that the animal lawyer that's interested in comparative law is going to have to spend quite a lot of time thinking about the other. How does the other view animals? How does it classify animals? Does it actually have categories of, in quotes, things, for want of a better term, that some people might think are animals, others might think are not, like plants, trees? Are they sentient? Do they have some characteristics that animals have? I mean, you can begin to see some of the problems here. That's just trying to classify the object that we're talking about. Now, what is an animal? Also, we need, if we're then going to say, well, we're going to be comparing law. As Catherine Valker says, she is one of Canada's leading comparatists. If you're a comparative lawyer, you're comparing law. So, what is law? This may be not such a difficult question when it comes to an English comparatist comparing the English lawyer comparing, say, German law, there is some understanding, of course, of what amounts to law. We may have different definitions. We can't assume there's the same mentality, that a German, French, English lawyer have the same mentality. But there's a kind of broad, because it's a European tradition, the whole law of European tradition, it would be idle to say that all the civil law learning over the corpus juris civilis has not seeped into English. Or as Peter Stein says, English legal theorists never had much to go on in England, so they tended to import doctrines from continental Europe, which of course were based on Roman law. But when you're then comparing with a culture that's outside what we might call the Western tradition, I know Western tradition is not really a very satisfactory category, but we can see that it's a real problem. I mean, traditionally, some comparative law books in the middle of the last century would talk about countries not having law. Not, this Asian country, for example, this African country doesn't have law. Now, that point was taken up by an American, very leading American comparist, Timisoara, who said that's just an example of Orientalism. This idea that, Asia does not have law is a form of racism, form of Orientalism, basing his argument on Edward Said's famous book, Orientalism. So you can see that trying to decide what amounts to law, what amounts to the other, that I can compare our law with the object. And there's Catherine Valker's book on comparative law that came out a few years ago, tries to tackle this question. Whether it does so successfully, I'm not sure it does fully successfully, but at least she makes a brave attempt to tackle an extremely difficult question. And that's something that all comparatists, that Alexandra, Simone, Pierre, myself, are very much aware. I'm conscious of time, so
I'm sorry to interrupt. I just want to let you know that if you want to set aside time for questions, we still have 10 more minutes. So
10 more minutes. Okay, right. Thank you. The second question is is the why question. Why do you want to compare? I mean, here, this is a far more important question. Sometimes, people just throw in a bit, oh, well, in France, they do this, to kind of beef up there. The golden rule here is simple. You only compare if that comparison in itself is going to produce knowledge that cannot be, if you like, produced by looking at just one system. I mean, let me take an example from comparative literature. You can look at literature in one country and a piece of literature in another country and compare. But what's the point of doing that? The only point of doing it is if it can produce knowledge that could not be produced by just looking at the English example of literature or the French example of literature. That is a fundamental point. And it's a fundamental point. Anyone doing research, they must include this or incorporate this into their research question. Now, I'm conscious of time, so I'm now going to move to the third, the how. How do we compare? Now, time after time, when I assess, and as I have been doing over the last 2 months, major research projects, I find quite often under the methodology section, things like I am going to use the comparative law methodology, full stop. There is no such thing as the comparative law methodology. It's like saying, I am going to use the sociological methodology, or I'm going to use philosophical method. It's meaningless. How you engage with the other is a question of grille de lecture or schemes of intelligibility. You can either engage using a functional approach, you can engage using a structural approach, you can engage using a hermeneutical approach, you can also engage actually using a causal approach. Quite famously, the legal origins movement was one in which researchers claimed that there was a causal relationship between the legal culture and economic efficiency. Now, anyone who knows anything about causation is soon going to, and a specialist on causation is soon going to know that these kind of assertions are pretty dodgy, because causation at the best of times is an extremely difficult topic, and some philosophers would say it's a complete fiction. Now, this is important for animal lawyers, because how are you going? What is going to be the means by which you engage with the other text? Imagine you're comparing texts, animal protection with law, or an animal protection text with text in other legal systems. Are you going to use functionalism? Good. What do these texts, what are they trying to do? What's their object? What's their purpose? That's different from a structural approach. A structural approach we've seen would be, for example, when we try to impose English categories or French categories on English law, trying to restructure the law, or a hermeneutical approach. What actually does this term mean? Very good example of a deep hermeneutical approach is work by Pierre Legrand, particularly his work. Actually, his work, he's done some quite very recently published a book with a chapter on animal law in his The Ways of Negative Comparative Law, published very recently this year with Routledge. There is a chapter, of, if you like, on a hermeneutical approach towards some animal law. Then we might think, of course, we have to think about the various concepts that are used. Ownership, property, of course, are fundamental. And then there is two concepts that are used often in animal law: rights, animal rights, and animal interests. Animal rights, I think, could, I'm afraid, give rise to several lectures in themselves. And it's an extremely difficult topic, because the concept of right itself is a very controversial notion. Is it ideological? Is it really legal? So these type of things. And do they apply only to humans? Do animals really have rights? Do New York rats have rights? What happens if I have a cat? Then, of course, that's going to intrude on the rights of lots of animals in my garden, that the cat will get. I mean, one of the problems of bird species in this country is that many are threatened by domestic pets. So these are immensely difficult questions, which I haven't time to get into, but we might want to discuss at some point. Other approaches to use.
Just to let you know, sorry, that we are approaching the end of your talk. So if you want to have some questions, then I think it would be good if you could conclude.
Okay, just finally then, another is interest. Actually, the term animal interest has been used in an English statute. Perhaps that is a more fruitful term. So, okay, just then to conclude, I've attempted to approach, or I mean, perhaps suggest that you approach with these three questions. If you want to approach animal law from a comparative position, three questions. The what question, what is the object of the comparison? The why question, why am I comparing, and of course the how question, the whole methodological scheme of engagement. And in order to do this latter one, you are going to have to move well outside the discipline of law and look, for example, at social science epistemology. Thank you.
Thank you so much, Geoffrey, for this wonderful overview of the history of comparative law, of its main epistemic challenges. I'm quite certain that many of our participants in engaging with comparative animal law have asked themselves, why? Why should I compare? What are the stakes of comparison? So since we only have about 5 minutes left, I will now just directly turn to the audience. Please feel free to ask your questions. I'm sure that comparison is challenging for you, and as animal law specialists, you now have the chance to express any, concerns, epistemic or methodological, that you might have. Does anyone have a question? If not, I would like to ask Professor Geoffrey Samuel a question related to the possibility of global animal law. I'm sure that many in the room are interested in the subject. Given it precisely that we have different perceptions of animals, their role in society, their relationship with us, what do you think about the possibility of a global animal law? Because on the one hand, we feel that the animal as a category is somehow universal and is, of course, deserving of the same protection, high-level protection. But on the other hand, it's quite certain that we approach animals from various, precisely, cultures, traditions. And so these traditions might act as obstacles or might, of course, shape the way we understand what our relationship to animals should be. So I would be very grateful if you could tell us a few words about your view on the possibility of global animal law.
Well, I have two approaches, 2 points to make here. The first is I'm very, very skeptical about any global law. I would have thought that we could, if we can't protect human rights, and I think all of you will agree that at the moment, over the last events over the last few days, few weeks, let alone, and certainly over the last few years, we can't even protect human rights. We can't even protect children from the most cruel events. That I think if we can't protect humans, then I think it's highly unlikely that we're going to be able to protect animals from a global level. So I think quite a lot of a whole idea of kind of global laws, transnational laws. I tend to agree with Pierre Legrand on this, that a lot of it is actually, in the end of the day, fantasy. And there's also, of course, a second problem, again identified by Professor Legrand and by others, that even if you have, shall we say, agreed global texts, each lawyer from different jurisdictions are going to interpret those texts from the mentality of their own legal system. And that can often be that can often lead to enormous differences. I mean, one of the most famous articles, one of the most well-known articles, of course, was Teubner's article on good faith, where he shows the notion of good faith in contract. That's often you find in a transnational law, like Unidroit or the principles of European contract law. Contracts must be formed and performed in good faith. What on earth does good faith mean? Teubner shows it means completely different things in England, France, Germany, so on and so forth. And I think that's going to be a major problem with global animal law. So I'm afraid these kind of harmonizations, these kind of global texts even if you get quite a whole number of countries agreeing to them. I think in the end that they are really, they're really often quite meaningless, as we've seen with human rights. So if we can't even be able to produce an effective human rights law, global law, then I don't think we're going to be able to do much with regard to animals. Sorry, but bit cynical. But does that answer your question, Alexandra?
Yes. Thank you very much. Thank you very much for your response. Thank you very much for your talk. It was a very insightful talk. We will share it with our participants. We will have the recording, and I'm sure they will be able and they will be encouraged to, after your talk, to turn back to it whenever the
We'll
challenges
see.
of comparative law will come to mind. Whenever they will have to tackle precisely what is comparison, how best to defend the interests of animals through comparative lenses. So thank you again, Geoffrey, for this most interesting talk. And I'll give now the floor back to